Senator Henkel. Mr. Speaker, honorable colleagues, I would first like to thank Senator Pattison for her sustained commitment to this issue. Thanks to her work and perseverance, the concerns of victims have remained at the heart of our debates. I would also like to thank the committee members and the witnesses who agreed to share their expertise and their experiences. At times, this was painful for them. My colleagues and I were very sensitive to this matter. As an honorary captain of the Canadian Coast Guard and honorary lieutenant colonel of the Maisonneuve Regiment, I have the privilege of interacting with women and men who have chosen to serve our country. I have great admiration for their commitment. I also have great respect for the sacrifices they make, as well as those made by their families. That is why I firmly believe that those who protect us deserve protection in return. In essence, that is the question brought forward by Bill C-11. Over the past few days, our committee has heard from survivors, veterans, police officers, legal experts, and other specialists who share a common goal: to better protect members of the Canadian Armed Forces who are victims of sexual offenses. Yet, many have concluded that there are different ways to achieve this. This is what makes this debate particularly difficult.
On the one hand, we cannot ignore the findings that led to this reform. For more than a decade, report after report and inquiry after inquiry have exposed the profound crisis of confidence within the Canadian Armed Force. The Deschamps, Fish, and Arbor reports were not commissioned without reason. They reflect a painful reality. Too many victims have felt that the very mechanism intended to protect them were not meeting their needs. With Bill C-11, the government has chosen to implement the central recommendation of the 2022 Arbor Report, which is to remove criminal code sexual offenses committed in Canada from the military justice system and place them exclusively under civilian jurisdiction. This is a significant decision, but it is also clear that it does not command unanimous support.
What struck me particularly during the hearings was that many of the reservations expressed about the bill came from stakeholders who usually hold opposing roles within the justice system. Survivors, military police representatives, military prosecutors, and defense lawyers have, for different reasons, raised similar concerns regarding the mandatory transfer of these cases to the civilian system. When people who normally find themselves on opposite sides of a courtroom converge on certain concerns, Parliament has a duty to listen carefully. This convergence did not mean that they opposed the bill's objectives. Rather, it meant that they feared certain consequences had not been fully considered.
Several testimonies reminded us that sexual assault is fundamentally a loss of control, and that healing often involves rebuilding that autonomy.
That this reform could leave victims with the impression that important decisions are being made on their behalf rather than with them. Others have drawn our attention to a particular dimension of the military context. When sexual misconduct is tied to an abuse of power, the issue is not limited to assessing whether a criminal offense have been committed. It also raises broader question of leadership, authority, responsibility, and institutional accountability. The testimonies have also reminded us that victims are not a uniform group. They do not all share the same experience, the same expectations, nor the same needs. Some believe that transferring these cases to the civilian system is essential to rebuilding trust. Others would have preferred to retain the ability to choose. I understand those concerns. I also understand the concerns raised about the civilian system's capacity to take on these cases. Several witnesses pointed to court delays, limited resources, and the challenges already encountered in the handling of civilian sexual assault cases. Some questioned whether we risk shifting the problem rather than resolving it. Indeed, the committee's discussions and the close votes that followed reflect the tension surrounding this bill. Only a few senators approached this study with absolute certainty. The committee's deliberation showed that it is possible to share the same commitment to better protecting victims while differing on the best way to achieve that goal. It is in this context that I consider the adoption of Senator Patterson's amendment particularly important. Cet amendement exige.
This amendment requires an independent review to be conducted within 3 years of the reform coming into force. This review must be the subject of a report to Parliament and be informed by consultations with victims and with military and civil justice systems authorities, as well as advocacy groups. In short, this amendment establishes an oversight and accountability system so that Parliament can judge, based on facts and concrete results, whether the reform is achieving its intended goals. This amendment reflects a form of legislative humility, the recognition that intentions, however laudable, are not enough, and that the concrete consequences must be measured. Having reviewed the study, I am not convinced that maintaining the status quo is a satisfactory response. For several years now, military authorities have been gradually transferring these cases to civilian authorities. This approach is therefore not entirely new. The bill essentially enshrines in law a practice that is already in place.
Above all, I believe we must recognize a fundamental reality. When an institution loses the trust of those it serves, rebuilding that trust sometimes requires profound change. It is not enough to say that things have improved. We must also ensure that mechanisms in place inspire confidence among those who may one day need to rely on them. It is in that spirit that I will vote in favor of this bill. I do so, however, without triumphalism and without claiming that this reform addresses every concern that has been raised before us. Le transfert de compétences vers le système.
The transfer of jurisdiction to the civilian system will not solve organizational culture issues on its own. It will not replace the need to properly train investigators, prosecutors, and judges on the realities of trauma. Nor will it replace the requirement for the Canadian Armed Forces to continue the work of cultural transformation undertaken in recent years. Above all, it does not relieve us of the need to monitor the results of this reform closely.
Us to measure the real-world impact of the proposed changes. I believe they're right. We will need to determine whether victims have greater confidence in the system. We will need to assess whether the results truly reflect the objectives we are seeking to achieve. In other words, we must be prepared to judge this reform by its results, not simply by its intentions. There is another lesson I take from our hearings. Time and time again, witnesses reminded us that support for victims does not begin at trial, nor does it end with a verdict. Judicial proceedings matter, but they are only one part of the journey. Support services, access to medical care, protection from retaliation, the ability to pursue a career, and the opportunity to rebuild one's life are equally essential and must also be taken into account. Le véritable test de cette réforme.
The true test of this reform will therefore not only be a question of where cases are heard. It will be a question of whether those going through these challenges feel more respected, supported, and heard than they did before. Only then will we be able to say that we have truly made progress. Thank you.
Which